Hey, my name's Matt Martens. I was a federal prosecutor for nearly 9 years and have been a defense lawyer for more than a decade. And I'm here today to answer your questions about criminal justice. The first question is, what institutions make up the criminal justice system? Well, there's a number of features of our system. Obviously, the police investigate crimes, prosecutors prosecute crimes, defense lawyers defend people who are accused of crimes. Sometimes those defense lawyers are private defense lawyers, and sometimes they're government employees who are appointed to represent people who cannot afford their own lawyers. And then judges preside over the criminal justice system. They preside over trials, deciding rules of evidence and giving the jury instructions. And then there's judges who consider appeals after the trial is over. And then ultimately, if someone's convicted, they could be sentenced to prison. And there are prison officials, including wardens, who manage those prisons. Our next question is, should the justice system focus on punishment or rehabilitation? As a Christian, I think the criminal justice system should focus on love. That the point of a justice system ultimately is to love our neighbors as ourselves, including the criminally accused. And punishing someone can be an act of love if it's designed to seek their good. That might mean teaching them, deterring them, teaching them that this is wrong and that they should not engage in this conduct. Whether you consider that rehabilitation or correction, I think ultimately the point of a justice system, if it's to be a biblical one, is to bring the criminally accused back into the community as a productive member. Our next question is, what is due process? Well, due process is a term that's used in our Constitution in several places. You could say it's the process that's due. It's the process that's owed someone. But more fundamentally, it's the process that is needed in order to ensure an accurate outcome in a case. The point of a process is not simply to have rules that confuse prosecutors or trip up defense lawyers. The point of a process is to work toward an accurate outcome, to yield a just verdict. That's the process that is due. That is the process that is owed as a matter of justice. Our next question is, what is plea bargaining? When people think of the criminal justice system, they often think of jury trials, perhaps because that's what they've seen on TV or in movies. But 94 to 97% of criminal cases in the United States are resolved through plea bargains, meaning some type of agreement between the prosecutor and the defense lawyer that the case will receive a certain sentence, or the person will plead guilty to some lesser charge perhaps than what they were originally charged with. There's an inducement to plead guilty by a promise of either a lighter sentence perhaps than someone would receive if they went to trial, or a threat that they will receive a more severe sentence if they do go to trial. So that's what we refer to as plea bargaining. The next question is, does plea bargaining undermine the criminal justice system? Ultimately, I think plea bargaining undermines justice. The way plea bargaining operates is by promising either a harsher sentence if someone goes to trial, perhaps harsher than they deserve, or a more lenient sentence if they will accept the plea bargain. And that more lenient sentence could be more lenient than they deserve. And ultimately, if justice is not only convicting the right person, but sentencing them in accord with their wrong, in proportion to their wrong, then plea bargaining really operates against that idea of justice. Our next question is, what is qualified immunity? You may have heard this phrase. It's become more popular in our culture recently. And it refers to a protection, a limitation on the ability to bring a federal civil rights lawsuit against a police officer if he or she violates your civil rights. Qualified immunity means it's not total immunity. There are, in theory, some circumstances under which the federal civil rights lawsuit could be brought. But the reality is, as the law has developed, those circumstances are so narrow as to be almost non-existent. There's a related doctrine known as absolute immunity, which applies to prosecutors, and as the name suggests, means they are absolutely or totally immune from federal civil rights lawsuits if they violate your civil rights. So for example, if a prosecutor hid evidence of your innocence in a prosecution, he or she would be absolutely protected, absolutely immune from a federal civil rights lawsuit if you were wrongly convicted. How does bail work? Bail is actually a concept identified in the Eighth Amendment to the U.S. Constitution, which provides that you won't be denied reasonable bail. The idea of bail is that you put up some amount of money to guarantee that you'll return for trial if and when your case goes to trial. If you don't come back, you would lose the money, you would lose the bail. And the idea is to ensure both that you will come back for trial and that you won't be punished prior to trial by detaining you before your guilt has been determined. But in 1987, in a case called Salerno versus the United States, the Supreme Court ruled that you could be detained, denied bail, not only because you were a flight risk, because you might not come back for trial, but also because the court concluded that you were too dangerous to let out. Too dangerous, that is, before you have ever been convicted of anything. And so now you can be detained prior to trial, you can be denied bail, not only because you're a flight risk, but also because you're determined to be too dangerous. Our next question, what are Miranda rights? Well, if you watch television shows about the police, you probably have heard Miranda rights, even if you haven't heard that word. It's the phrase that you often hear repeated where the police say you have the right to remain silent. If you give up that right, anything you say can and will be used against you. You have the right to speak with an attorney. If you cannot afford an attorney will be provided to you. It's a recitation of your legal rights under the Constitution, your right to counsel, your right not to incriminate yourself, rights found in the Fifth and Sixth Amendments to the U.S. Constitution. And that right to be advised of your rights was recognized by the U.S. Supreme Court in a case called Miranda versus Arizona, and thus the name Miranda rights. Our next question is, does the justice system favor the rich? Well, that's a complicated question, and there's probably different answers depending on which feature of the justice system you're talking about. But certainly one area where the justice system favors the rich and disfavors the poor is when it comes to the right to counsel. Those who have money can afford lawyers, but those who don't have money, those who are poor, while they have a right to counsel under the U.S. Supreme Court's decision in Gideon versus Wainwright, the reality is states are not providing enough lawyers for the poor, and that can skew the system against the poor and in favor of the rich. Another example of how wealth can impact the justice system is when it comes to bail. That two people who are subjected to the same amount of bail in order to be released prior to trial, one may be able to afford it because he or she is wealthy, and one may not be able to. It's been estimated, for example, that the average bail amount in the United States is $10,000. But for many Americans, that's an impossible sum of money. It might as well be $10 million. Our next question is there discrimination in sentencing? Again, a very complicated question because each case is different, and so it's hard to compare particular cases one to another, particularly when you have different judges presiding over those cases. But we do know, for example, in the instance of the death penalty, that detailed statistical studies have been done trying to control for all the other factors that could be influencing the sentence. And what those studies have shown, and frankly, no one really contests the finding of those studies, is that the race of the victim does impact whether or not someone is sentenced to death. Someone is more likely to be sentenced to death if their victim is white than if their victim is black. Our next question is, how many states have the death penalty? Currently, 27 states in the United States have the death penalty. That's a significant reduction in recent years, as a number of states, including my home state of Virginia, have by law eliminated the death penalty. But ultimately, while 27 states have the death penalty, only a few states carry out most of the executions. The vast majority of executions since the death penalty was reinstated in 1972 have been carried out in Texas, Oklahoma, Florida, and Virginia. Next question is, how do people support the death penalty? Well, people support lots of things that you may disagree with or that I may disagree with. As Christians, people come to support the death penalty, I think in large part due to Genesis 9:6, which speaks of shedding the blood of those who shed the blood of others, and Romans 13, which speaks of the state bearing the sword being an instrument of death. But many other Christians wrestle with that, particularly in light of Christ's command to love our neighbors and to turn the other cheek. And so different Christians over time have reached different conclusions. I think the Bible does allow for the death penalty, but it places constraints on our ability to carry out that death penalty, insisting that we be accurate and that we render justice impartially. And with regard to those two requirements, I believe the American justice system falls short. The next question is, how do people receive multiple life sentences? Well, when someone's convicted of multiple crimes, perhaps say 2 murders, they will receive a sentence for each of those crimes. The idea being that we want to speak to the seriousness of each of the crimes committed, not just one of the crimes committed. So for example, if someone's convicted of 2 murders, they could receive a life sentence for each of those murders. But obviously the person can't serve 2 life sentences because they only have 1 life. But we want to, as a society, speak to the seriousness of both the crimes committed and thus render sentences for both of those crimes. Our next question is there such a thing as a victimless crime? Well, I guess that depends in part on whether you're a Christian and what you think about crimes that might not be against another person, but might be against God. When we refer to victimless crimes, we're usually referring to things like drug use or prostitution, where the person who's committing the crime is not using violence or doing direct harm to someone else. But even when people engage in those acts, they're violating God's law and they're harming themselves, as we as Christians believe. And so in that sense, there are no crimes that really have no victims. The next question is, does America have the best justice system? Well, it's certainly a system I love. It's revolutionary. We fought a war in many respects over the features of the justice system that we take for granted today. It's a great system, and there's much to love about it. I don't think the right question for the Christian is it the best system that exists today? I think the right question for us is it the best we can do? Can we do more with the stewardship we've been given as Americans, with the resources we've been given, both financial and scientific and constitutional? Can we do more to love our neighbors better? And in that respect, I think there's always room for improvement. So those are the questions. I hope you've learned something from this. Criminal justice is an important topic, but it's a topic about which many of the things that lawyers take for granted are a mystery to perhaps people like you. I hope today you've learned a little bit more about the American criminal justice system.